Now, let's talk. Doug wanted me to talk to you a little bit about anchoring because we use this also to talk about anchoring. Anchoring is powerful stuff. And it is so powerful that Kahneman, in this book on persuasion, does an entire chapter just on anchoring. Okay? Anchoring, first of all, you utilize your courtroom space. And you anchor your locations. And one of the things that we learn from the actors who work with us when we teach a college here every year, and one of the things we learn from the actors is you always have a purpose for every movement you make. You know, this is not how you do a closing argument, looking down at the floor and with your hands behind your back. You have a purpose. When you move in the courtroom, you're moving from this juror to this juror to this juror. And be sure you cover them all, but don't move from this juror to this juror to this juror to this juror. Oh, I'm next? Yeah, okay, hi, yeah. You have a purpose. There's a purpose for movement. So anchoring in a nutshell is this. Let's see if I got a slide on it. Okay, so you have anchoring like this. Physical location. And during the course, let's say you're talking about a mental anguish, physical pain, general damages. And so you come to, when you talk to it, you come to this board, you've got this chart up here, and so when you examine a doctor about that, you always come to the same location. You talk about, all right, doctor, let's talk about the physical pain involved in this, and so forth. So then you're using the same graphics, you're using the same words, using the same vocal tone, and then you never question about anything else from this location. This is strictly your general damages location. You want to talk about liability, you go to a different location in the courtroom. You want to talk about a defective design, you go to a location and you use that there. But the same vocal tone, same verbal tone, and the same substantive evidence. Now, what does Kahneman say? And I'm going to tell you one that was pretty shocking, actually, about the other part of anchoring. Here's what Kahneman says. Anchoring can be measured, and it is an impressively large effect. Now, this is a guy who got the Nobel Prize for this, so you might want to listen to him. Anchoring can be measured, and it is an impressively large effect. Now, let me tell you about numbers. This is a test that Kahneman did. They did with 15. They had with German jurors who had at least 15 years on the bench. They read a description of a woman who shoplifted. That's all. They read the event. Then they rolled a dice. They rolled a dice, just one at a time. The judges did this independently. They would roll the dice. The die was always set to come out it was loaded to land on either 3 or 9. That's the only 2 numbers could come up. They'd roll the dice one time, and then they'd either get 3 or 9. The dice stopped. Then when the dice would stop rolling, they would say what their sentence would be, and they sentenced to more or less than the number on the dice. Okay? The rolling of the dice has absolutely nothing whatsoever to do with a fair and just punishment, obviously. But then after they decided what their sentence would be, they specified what the sentence would be. The average was those who rolled a 9 sentenced this woman to 8 months. Those who rolled a 3 sentenced the woman to 5 months. That is the anchoring effect of numbers. My point is, be extremely careful what numbers you toss around in the courtroom when you're in the sentencing phase. If you ask for a smaller number, if you're talking about numbers, be sure you've got an anchor. You want to anchor it to a reasonable number. The minimum dictates, the decision. Let's say the jury is punishing. The decision of the amount of time that should be given in this case is completely up to you. But The minimum dictates of justice require that it be absolutely no more than whatever. Pick a number. Pick a low number. It has an effect. The way we use it in personal injury litigation is if I can get a juror questionnaire, I'll have a question on a juror questionnaire that they fill out before the voir dire examination. And the question will be, if the evidence supports it, I can award $5 million in this case. Answer yes or no, and if you answer no, explain why. Well, if they explain why, that'll pull out the tort reformers and help you identify them and use it as grounds to strike them. But what you've done is you've anchored them to that number. We do a trial here every year. We do an advanced college that I started here back in '88, and we do a trial. This is with very experienced lawyers, and we bring in Harvard students as our jurors. And so then we put them in. We try the case. I was a judge. We try the case. We put them in. We let them deliberate, and we film them, and we bring them back out and. They spend almost no time at all talking about damages, although that was the big issue in the case. And they returned an award of $3 million. And so then I brought them back out and debriefed them. And you should have seen it. You should have seen their expressions when they realized that they had been filmed the whole time. Everybody's thinking, okay, did I tell any lawyer jokes? Did I say anything? So the answer to the question was $3 million. So I asked this question. I said, suppose, because the plaintiffs had asked for the lawyers that argued the case had asked for $6 million. And I said, okay, what would have been the award? Each one of you right now, write down your award of what you would have awarded if they had asked for $12 million. Everyone said $6 million. They just assume that they're asking for twice what they want. So there's an effect to numbers. Be extremely careful about numbers that you're talking about in the courtroom. Okay, I will talk about the availability bias. This is an extremely important thing. I call it the spotlight theory. The jury will focus in deliberation where the spotlight was placed during trial and summation. You get to choose where you want to place the spotlight. Be careful about putting too much information on about your own plaintiff, or your own defendant rather, because that's where the person they get the most criticism. The person that has the most evidence gets the most criticism. I want to show you how this works. The whole idea is focus. Now I'm going to put this up here. I want you to focus. Pick one card to focus on to see if I can get you to focus. This is spotlight. 3 seconds. Okay. Now, if I got you to focus in the right spot, your card should have disappeared. Okay. Now on the availability bias, what you're trying to do is you have to pick, and you test this again on in your focus groups. What is the evidence you really need to focus on? And you do this, you get to the point by, you take every bit of all your possible testimony, lay testimony, expert testimony, demonstrative evidence, and documentary evidence, and pick out what is the most important thing that I need to get the jury to focus on. Where does this piece of lay testimony fit into my trial story? And am I putting a lot of superfluous things in here that I don't need? Do you get in, make your point, get out? That's always been my theory of trying lawsuits. You get in, you make your point, you get out. I don't really have time. Just don't do that. So you test it with focus groups. Now, I'll get back to the reason that the consistency of your message is so important is because of trustworthiness. Now, I'm skipping around a little bit here because I'm short on time. couple of things that, another psychological principles, reactive attribution. And if you can put your defendant in this position in any way, it helps you. If you can show that the defendant, your client, was in a reactive mode, that they were not the person who caused the initial action, but they are reacting, then a jury has a tendency to forgive that. We all have a tendency to forgive people who are simply reacting. Maybe they didn't react properly, but it's not nearly as bad as purposive attribution. Purposive attribution, if you can show that someone else was acting on purpose, not willfully, but just on purpose. They decided, they chose to act that way. Purposive attribution, they'll actually, depending on how bad it was, they'll actually bring about punishment. So you play down the purposive actions of your defendant and stress the reactive attribution. The case right now of Susan Bland in Texas, in Waller County, she was reacting when the cop comes up and tells her get out of the car and all this sort of thing. She was in a reactive mode. All she did was she didn't put on her turn signal. Actually, the police officer was riding behind her, and so she's moving her car over she's changing lanes to let him go by. She changes lanes without putting her signal on, so he pulls her over. Simple situation, write a ticket, it's over. Give a warning, it's over. Instead, he's get out of the car. Now she's in a reactive mode. So if you had that case, if you're talking about, then if you prove that your person is reactive, you're in a much better position from a psychological viewpoint.